Hello, my name is ScophiaFleming, and this is my research case study presentation. Firstly, we will start off by giving the definition of defamation and the types of defamation as it pertains to the presentation in cases. Defamation is the false statement presented as a fact that causes injury or damage to the character of the person it is about. There are three types of defamation. Libel is untrue defamatory statement that is made in writing. Slander is the untrue defamatory statement that is spoken orally. And malice is intentional commission of a wrongful act, absent justification with the intent to cause harm to others. So now we're going to go ahead and take a look into cases of defamation. The first case is the case of New York Times versus Sullivan. The parties are New York Times, an American-based newspaper, and L.B. Sullivan, who was the Public Safety Commissioner of Montgomery, Alabama. Sullivan argued that the ad posted in the New York Times titled, "Heed Their Rising Voices," provided the public with false information and shed a negative light on a police department that he supervised at the time. The Sedition Act of 1798 made it a crime to print anything false about the government, president, or Congress. The Supreme Court later modified this when it enacted the rule that a statement against a public figure is liable only if it is known to be false or the speaker had a reckless disregard for the truth when making it. Sullivan would need to provide that there is evidence of actual malice. Actual malice is described as intentionally and maliciously publicizing false information in order to damage a person's, particularly public official's, character. Since actual malice could not be proved in this case, the U.S. Supreme Court ruled in favor of the New York Times, citing that the newspaper could not be held liable. There was not enough evidence to rule in favor of Sullivan, and the First Amendment provides journalists the freedom to post any statement, even though labeled as false. The second case that we will take a look at today is the Gertz versus Welch case. The first party in this case is Elmer Gertz, who is a lawyer whom represented the family of Ronald Nelson, which was an individual shot and killed by Chicago police officer Richard Nussle. The second party of this case is Robert Welch, founder of the John Birch Society, which is an advocacy group that is not in favor of communism and limited government. Elmer Gertz, whom was the petitioner, is a private person. The article in American Opinion accused Gertz of arranging Nussle's conviction and cited that he was a member of many communist organizations. It also made allegations towards Gertz's own criminal history and used derogatory terms towards him in regards to being a communist. Alan Sting, author and or contributor to the article, made no attempt to verify the information was accurate before the article was published. The defendant only verified the information in the article under previous experience of the contributor and did not fact-check the article before publication. The defendant only sought to verify the allegations after the suit was filed, but the request was not granted by the court and adhered to the plaintiff's, which was Gertz's, objection. I personally believe that these allegations may have caused the public to question Gert's reputation and may have altered the number of people whom consider Gertz for representation. However, I believe that through the results and verdict of the case, his reputation was uplifted. I would have definitely sought to verify any information imputed in an article before publishing it. The information in the article needs to be proofread numerous of times, and the information should be thoroughly cited. Under the Florida law, the elements of a defamation claims are the defendant published a false statement about the plaintiff to a third party and the falsity of the statement caused injury to the plaintiff. A plaintiff must also prove that the defendant's fault in publishing the statement amounted to at least negligence. The elements of a defamation claim in Florida are similar to the elements discussed in the general defamation law section, with the following exceptions. Defamation per se. In Florida, a statement amounts to defamation per se if it accuses the plaintiff of committing a crime or imputes the plaintiff's conduct, characteristics, or a condition incompatible with the proper exercise of his or her lawful business, trade, profession, or office. Public and private figures. Florida has a broad definition on whom is considered a public or a private figure. Criminal libel. Florida still recognizes criminal libel, unlike other states. And actual malice and negligence. In Florida, a private figure plaintiff bringing a defamation lawsuit generally must prove that the defendant was at least negligent with respect to the truth or falsity of the allegedly defamatory statements. Public officials, all-purpose public figures, and limited-purpose public figures must prove that the defendant acted with actual malice, also known as knowing that the statements were false or recklessly disregarded their falsity. The case between Sullivan and Gertz has taught me that all information should be verified, especially when there are allegations being made against the person. Keeping this in mind will ensure that false information is not being made public and that no one's reputation, even as a journalist, is not on the line due to defamation claims.